must send out a strong message to other would-be offenders who fire shots among crowds and endangering the lives of others, that if you commit a crime, you must do the time. And that's their conclusion there. Then, Your Worship, as I already said, they filed supplementary heads of argument last Thursday, and there's a lot of, with respect, repetition, Your Worship. We'll see. The introduction is very similar. They highlight the charges that he faces, and they concede in paragraph 4, and this is where they go against the previous heads, that the minimum sentence legislation does not apply because he had not been warned accordingly. But they asked the court to impose a custodial sentence, and they do the aggravating features of the case, and they repeat everything that they said in the previous heads. There's nothing with respect new, so I don't know what was supplementary about this, Your Worship. And they then, in paragraph 9, attempt to deal with our heads of argument and to respond to the heads of argument, and they say in paragraph 9, this distinguishing feature of premeditation places this case in an entirely different category from every authority cited by the defence counsel in favour of a non-custodial sentence. In Pastorius, the restaurant incident, the discharge was negligent. In Munsam, it occurred in a moment of intoxicating impulsivity. In Falun, it was a crime of passion. None of those cases involved a public leader who planned to discharge live rounds from 2 firearms before 20,000 people as a rehearsed act of spectacle. And once again, Your Worship, I highlight, they tell you all along, treat him like a normal person, but they keep highlighting with respect that he's the leader of a political organisation and you must punish him accordingly. So it's self-defeating with respect. They then also, in paragraph 10, they have a heading beneath it, 2 firearms, 22 live rounds before 20,000 people within a community. And they refer to the firearms being a 9mm handgun, Narinka SPA 24914 5.65 by 45mm, Remington semi-automatic assault rifle. But Your Worship, what they failed to report here, or even considers, they gave that back. So if they believed that an offence had been committed, Your Worship, and it was so heinous and it's a prohibited item, I don't understand the sense of having returned it to its lawful owner, but that they don't have any regard to. And they say that such a firearm, in paragraph 11, retains lethal kinetic energy on descent. The potential for mass casualties was real, foreseeable and scientifically established, but we have the objective fact, Your Worship. And they say that it's pure fortune, that nobody was injured and there was no damage whatsoever, Your Worship, which is a factor that this court took into account in the judgment and ought to take into account in the sentence. It's one of the most important factors we take into account. And that's what they say in 12, Your Worship, that no one was killed or seriously injured was a matter of fortune, not mitigation. And then, Your Worship, in 15, they say that this conduct is a harm to the values of constitutional democracy itself. And in 16, again, they say the court is therefore called upon not only to punish the accused for his individual conduct, but to vindicate the constitutional principle that public office and political prominence do not confer immunity from criminal sanction, which is the point that I'm making repetitively because they seem to go between those two approaches with respect to Worship. They then also refer to the decision of Hewitt as did we, and then they claim that the accused not only had an absence of remorse but also insight and accountability, and that he had maintained throughout and continues to maintain that he committed no offence despite being convicted after full trial on overwhelming evidence, which is the issue that Your Worship dealt with on record and recorded that it was his right, constitutionally recognised right to plead not guilty. And then they say that he described these proceedings as an abuse of the NPA resources, an incompetent prosecution attributed the undisputed discharge of 22 live rounds to political vendetta by AfriForum and others, including the President of the Republic, racism, and even the Holy Spirit. And what they say that he sought throughout to conflate the rule of law with political persecution. And they then deal with Ms. Thompson, which, I don't know why they had to do this in a supplementary set of heads, but it's a lot of repetition. And this is where they made they say she made a concession in paragraph 20 that they described as remarkable, and we say that doesn't appear from the record. We didn't have the record at the time, nor did they, so it's understandable. Maybe that was how they interpreted it, because Your Worship knows, we received the record from Your Worship very recently. But in 20 they say that firstly and most significantly, Ms. Thompson conceded under cross-examination that she could not find a single case in the literature where a non-custodial sentence had been imposed with unlawful possession of a semi-automatic firearm. This concession is remarkable. It speaks not to the uniqueness of a lenient outcome, but to the settled judicial view that such offences call for custodial sentences, a view Parliament endorsed through the enhanced penal jurisdiction in the FCA. Now that cannot, with respect, be correct. We handed, my learned friend wasn't aware of it, which I do concede, the more recent decision of the Eastern Cape, to Your Worship, where there was possession of an unlawful firearm, which was an illegal homemade firearm, and there was no custodial sentence imposed, and we dispute that such a concession was even made, Your Worship. We don't find it in the record. I know that sometimes the records aren't 100% accurate, but my learned friend can elaborate on that, because that appears from the supplementary that's filed last Thursday. Then they deal with the issue of Ms. Thompson's recommendation premised on a characterization of the possession as brief, benign, and celebratory. On the brevity, they say the brief duration of possession is relevant only where possession is accidental or fortuitous. They say here it was pre-planned and deliberate. Benignity, 22 live rounds. They said the ballistic risk was extreme. Celebratory purpose, they said the law does not distinguish between a reckless act done for enjoyment and one done for malice in assessing objective dangerousness. The rest we say is a repetition, but then they say, Your Worship, in 22. Fourthly, Ms. Thompson's assessment of the risk of recidivism was superficial. She relied on the mere passage of time since the offence. She did not grapple with the fact that the accused who leads a political party that has staged multiple large-scale events since 2018 has demonstrated no acknowledgement that his conduct on 28 July 2008 was dangerous or unlawful. The absence of reoffending in the interim is not on its own indicated that no such risk exists. Now, recidivism is defined as the tendency of a convicted criminal to reoffend, relapse, or go back to its way. And that's the clearest indication is looking back on time to say, did such a thing reoccur? So we submit that Ms. Thompson is accurate in that regard, and they, with respect, seem to have misinterpreted the term recidivism, and it wasn't superficial, because we look back in time, we say, were any other offences committed in that time, in the past 8 years? And the answer is no, because the clean SAPS 69 was handed in, so it doesn't appear that she's inaccurate in that regard. They then respond to our submissions, Your Worship, on sentence, and they dispute that celebratory discharge cases are distinguishable. They say that you do have outcomes where there are no, I think that they say they're distinguishable. And then, as it was dealt with in the previous heads, Your Worship, they say Pistorius, there was no premeditation. In Munsami, the accused were intoxicated police officers who fired at a canoeist in a moment of madness. For Yun was a crime of passion. Vader was a firearm and reckless endangerment, not discharge. So they say they're all different. And we say yes, Your Worship, but at the same time, the most glaring fact, Your Worship, is they could not find one case in our whole history of all our cases, Your Worship, of shots being fired at a funeral or a celebration that resulted in a prosecution. And that's a fact that stands out on its own, Your Worship. And then they say the no harm, no injury argument misrepresents the nature and gravity of the charges. And they say no one was injured, no property was damaged. The state acknowledges this, and that this they describe as being purely fortuitous. But what they don't mention here, Your Worship, and Your Worship went through the trial, so Your Worship knows, there was not one eyewitness that came to testify before this Honourable Court. The state was dominus litis. If anybody was in fear, out of all those 20,000 people that they now rely upon, it was incumbent upon them, either in the trial, Your Worship, or even in aggravation of sentence, to lead that evidence, but they didn't. Even the SAPS who were on the stage, Your Worship, were not called by them to testify, even in aggravation of sentence, Your Worship. Not even the gearhouse people, Your Worship, said that they feared or were worried for their lives or ran away. No single person stood before this Honourable Court saying, I was afraid of being injured. I saw this as reckless, callous, and dangerous, which is something that they ought to have led if they wanted to prove that there were aggravating circumstances. They then, Your Worship, tried to fall back on their previous heads of arguments and say even where the minimum sentencing regime does not apply to case law, establishes a clear sentencing range for unlawful possession and discharge of semi-automatic firearms. They then quote our constitutional cases that we quote. The principle is clear from that from the case of Makmanyani, Your Worship, and EFF versus the Speaker. Then they turn to the personal circumstances of the accused, and they say it's a double-edged factor. It may be often a mitigation of personal circumstances. That is a public leader and member of parliament, but they say this is the most significant aggravating feature of the case. So now, Your Worship, they argue, treat him like any normal human being. At the same time, they say, no, this is the single most aggravating factor of the case. The two are mutually exclusive with respect, Your Worship. They acknowledge, Your Worship, in F, that all 5 counts arose from a single continuing incident, but they say the remaining counts serve to aggravate the primary count, not merely to make an example of this accused because he's the leader, current leader of a political party. Then they tell you, no, there's an imperative. You must make us all equal before the law. And they say it in themselves. They say a sentence that treats his case as an exception to well-established sentencing norms would itself be an act of unconstitutional discrimination against the poor in favour of those with means and the powerful. Now what we're saying, Worship, is they seem to imply that to impose a fine would be unconstitutional. It's not the case, Worship. One can impose a fine. It's recognised even in the post-constitutional era that a fine is a punishment, as is a suspended sentence, as are other forms of punishment. They're recognised. Then they ask for the imperative of proportionality and the imperative of deterrence. And then they repeat themselves, Your Worship, in paragraph 35 yet again, where they say, and I'm going to quote because we'll see just how many times they've said this, the accused has treated these proceedings with contempt. This is from the previous head, Your Worship. He fabricated a false account of a toy gun that was comprehensively dismantled by the overwhelming evidence at trial. He refused to cooperate with investigators. He characterized this prosecution as an abuse of the NPA. He blamed VIP protectors, the Holy Spirit, and everyone except himself. The show is over. The court must now ensure that justice is done, not because the accused is prominent, but because the rule of law requires that every person who commits a serious offence faces a serious consequence. And they therefore go back to the zone as they did in the previous heads and ask Your Worship to impose. Now, Your Worship, what's lacking from all of this, and which leads into the allegation by the accused that this is an abuse of the NPA, is the objective fact, Your Worship, that we as a team and the state as a team, and I believe Your Worship too, were unable to find any case of any single individual who's ever been prosecuted for firing shots at a funeral or at an event or a celebration, despite all of us having seen that regularly on our TV, on the news, etc., etc. We therefore say, Your Worship, that a more appropriate sentence, taking everything into account, would be to take all the charges together that arise from one incident and to impose a non-custodial sentence which may incorporate a fine and a suspended sentence in any other order, but to incarcerate the accused, we say, would be startlingly disproportionate to the offences. Thank you.
Thank you.
I know I have another right to reply. My other friend's in a difficult position because his heads have been alluded to, but I'm sure he's going to add to them as well and deal with.
Yes, and then obviously you may reply
Yes, Your Worship.
if something.
I think
if
Mr. Mike told you to the reply.
Oh,
With your leave. Thank you.
Advocate Otis, there's just one aspect that I want to ask since you've raised it
Yes.
now, and I've read it in the heads and heard in the evidence of Ms. Thompson, and that is the part of the firearm being handed back before the court passed judgment. That is not within my knowledge. So,
It is, Your Worship. It's in a report. She's testified.
no, it is in a report. I'm saying it's not within my knowledge. I'm hearing it from the defense.
No, Your Worship. Yeah, there was no evidence. No, there was evidence that she testified to that.
No, I don't
It's
think
in her
you.
report and it's in her testimony. And Your Worship, it's a logical conclusion. My learned friend, who was in court and would be aware of it, never disputed it once.
Yes. No,
So-
look, no, maybe I'm not. I heard her saying so. There's evidence by the defense regarding that. I'm just not sure where it's coming from. You don't have to. I accept it's there, and as you say, it wasn't challenged. But it's not within the knowledge of the court that it was returned before judgment.
That is, Your Worship. It's in her report. She was led on it. No, I was also standing by, so you'll find I've given Your Worship the page reference.
No,
and
I've
the
seen
report
it.
reference.
I know it's there. I do confirm it is contained in her report and
had
in her
it,
evidence.
had it not been the case, Your Worship, my learned friend was obliged to challenge on it, and he didn't. So it's an objective fact, and it's evidence that was there before this honourable court. I don't know why there's a noise, Your Worship, and I don't align myself with it.
No, it's
So
the
let me
same.
repeat what I say, Your Worship. She testified, as Your Worship knows, it's in her report, and my learned friend was present and never ever cross-examined on that aspect. So, with respect, in our submission, it's a proven piece of evidence before this honourable court.
Look, just I hear you, I agree, and then I saw it in your heads, and that's why I thought I'll ask, because I'm not sure what the source of that information is, but it's neither here nor there. As you say, it's on record. I'll hear if the state has any reply to it, but it's not. Thank you. It's so noted. Thank you. All right, Advocate Caesar, are you ready or?
I think we must get this over and done with. Thank you, Your Worship. I'm ready.
I know it's inconvenient, you don't have to move. We do have lady staff here who are requesting a bathroom break, which is 5 minutes. We can return within 5 minutes. Don't want to put anyone on the spot,
It's
but
perfect, Your Worship.
I'll just leave all my stuff right here, so I don't have to carry anything. Don't know who else, but sorry, the public, the gallery. If you do need to go out for facilities or water, etc., just please stick to the time frame so that we are back in time to proceed, because it's a lot who has to go out and back, and then 5 minutes becomes 15. So I know everyone can't manage in 5 minutes, but I'll be right here. Sorry for that. Let us just...
Your Worship, when I was at the magistrate's course many years ago, they had this 3D dimension on the board where we each were required to say or what exactly was on that particular 3D dimension. Some saw elephants, I saw a head of a man, an old man, even some saw a lion, some saw 3 heads. The point that I'm trying to make, Your Worship, is that we're looking at the exact same set of facts with different views relating to that particular fact. That is the court's duty to find which one is the more plausible argument. It's not for me to minimize counsel's argument and vice versa. There's just 2 aspects that I need to rectify right from the beginning. The issue relating to the filing of heads. My heads, I confirm it was filed on the 1st of April. The issue that I need to address is the condemnation issue, because I did call Mr. Mkwanazi on the 31st, informing him that my heads are ready, it's ready to be filed. I wasn't in office, I was on the road, and I did not want to send unsigned heads, which he confirmed that there will be no issue. Why counsel raised it like I had to apply for condemnation? To me, that is sufficient. It was filed first thing on the 1st of April when I got back to the office. The second issue that I also relating to the condemnation, I did not read counsel's heads on the 31st. Reason being, as already explained, I was on the road, I was not in office, I was unable to read it. That's the reason why I contacted the attorney Mr. Mgwanazi, because I did not have any other person's number. It's my view, a response to the heads of council in the supplementary heads. There's no need to apply for condonation on that aspect. That's a matter for debate. The second issue that I want to address is relating to the firearm that was given back to accused number 2. It was given back to accused number 2 on the day when he was found not guilty. There was a prior agreement between the attorney for accused number 2 via emails that was sent to one another between me and that should accused number 2 be found not guilty, that the firearm would be returned. If he was found guilty, the position would have changed drastically. The issue about the firearm being given back, it's our submission that that is a storm in a teacup. We are fully within our rights. If you read Section 30 of the Criminal Procedure Act, Section 31, which allows us to give the firearm back if there's no need for the firearm to be kept further. If I might read, just to assess counsel, what this particular section says relating to that. I don't know if it's the lights or what.
I think it's the bright light behind you may cause a glare, I'm not sure.
Can I ask my neighbor, because so I would actually ask counsel to read that particular part for me. You must read Section 30 and then Section 31(1) because I can't see. I don't know if it's the
Just borrow someone's spectacles that forget Caesar.
It's time. It's time.
It's time that you go and get spectacles.
Sure.
Oh, he's got them there, look.
Yes,
Sorry.
I got the spectacles.
Now we are in a spectacle. All
Much,
right.
much better. Section 30 deals with disposal by a police official of an article after seizure. A police official who seizes any article referred to in Section 20, which we know it's articles which they lawfully entitled to seize from an accused or a suspect or any person who is suspected to have committed a crime, to whom any such article under the provisions of this chapter delivered may, if the article is perishable, with due regard to the interest of the persons concerned, dispose of the article in such a manner as the circumstances may require, or may, if the article is stolen, property or property suspected to be stolen, with the consent of the person from whom it was seized, deliver the article to the person from whom, in the opinion of such police official, such article was stolen, and shall warn such person to hold such article available for the production at any resultant criminal proceedings if required. I'm not going to read the last one, C. I'm going to go to Section 31, subsection 1A, that deals with this particular issue. If no criminal proceedings are instituted in connection with any article referred to in Section 30C, or if it appears that such article is not required at the trial for purposes of evidence or for purposes of any order of court, the article shall be returned to the person whom it was seized, if such person may lawfully possess such article, or if such person may not lawfully possess such article, to the person who may lawfully possess it. We had no need for that firearm anymore after accused number 2 was acquitted. They didn't need to come and apply or bring an application for the court to make such an order. We did not deem it necessary. It was well after within our rights, after consultation with the investigating officer, that such article be returned and that it be warned that such article may be made available maybe at a later stage. That is exactly what happened. It's my submission that this issue about the firearm being returned is a storm in a teacup, because we were perfectly within our right to return it. The investigating officer has retired. If that article had went missing in his absence, it would have caused a greater problem. So that's why the decision was taken to give him the article after he was found not guilty. Ms. Thompson's evidence regarding that particular article, she was not cross-examined because that is evidence that she got from the accused or whoever was informing her that that particular article was given back. It's the same storm in a teacup that was made about the laptop, where the video evidence was stolen, despite the fact that it was kept on another hard drive. The laptop was a non-event, so we didn't need to focus on that particular issue. The evidence was still there, it was already collected, just as the article prescribes. Since that issue now has been dealt with, and the law allows us to do so, I want to deal with the issue relating to Section 9 of the Constitution, because that is where everything starts. It guarantees equally before the law and the right to equal protection and benefit of the law. In the context of criminal offenses, the Constitution obliges the court to protect and promote the rights of every individual, ensuring that no person is above the law. I will get to this particular part in a later stage, just to respond to what counsel was referring to about the double-edged sword relating to the accused being treated equally before the law like anybody else, and the fact that we mentioned that he was a public figure and that he should get a more severe sentence than the normal man on the street. Insofar as sentencing was concerned, the court is well aware that courts are obliged to take into account the aim of sentencing, which is retribution, rehabilitation, prevention, and deterrence. The court must consider the personal circumstances of an accused, the seriousness of the offense, and the interest of society. I'm not going to go through my heads page by page, but we have referred to State versus Banda and others.
Sorry, Advocate, so I follow you. Are you doing a combination of the first and second, or which one are you busy with now?
I'm busy with page 2.
Of the first?
Yes,
first.
it's the first one.
Thank you. Just so I can follow you. Thank you.
Yes, the accused's personal circumstances was well articulated by the probation officer, Ms. Thompson. I will deal with the flaws of her evidence when I refer to my supplementary heads of argument. It seems that basically she relies on those factors: that the accused did not injure somebody, that he possessed the firearm for a short period of time, and then she made a recommendation, because he also have a soup kitchen that he is responsible for, that he should get a non-custodial sentence. I want to add to this point, Your Worship, that I also received the matter, the judgment on sentence of Justice Brooks, this morning. I am going to go to it, but I will deal with it briefly, just briefly. If the court allows me time to read it properly, I can produce many similar judgments of the same judges in the same division where they differ from opinion, which is within their right to do so. I didn't deem it necessary to hand this particular judgment up by the DJP, the Deputy Judge, now retired Judge President Van Zyl, where he has an opposite view regarding firearms. The matter of, it's an appeal matter, a full bench appeal judgment, the matter of Romeo Jansen, the case number is CANR 220/18. I just want to see the date when the judgment was delivered on the 29th of August 2019. This is a full bench matter where he held the exact opposite view of what Justice Brooks held regarding the possession of firearm. And this already outweighed the judgment as counsel has handed up of Mr. Nolan Linzima Ndila, because this is a full bench judgment of the same division. I'm going to give counsel a copy as well, if I may hand it up for the court's benefit.
Thank you.
Your Worship doesn't even have to be concerned. The fact that that judgment already outweighed this one, which is by a single judge, the court can rest assured, because the Supreme Court of Appeal already dealt with this particular issue relating to firearms. We know that the Supreme Court of Appeal is the highest court, and then the Constitutional Court, the apex court. So the reason why these judgments are relied on by the Supreme Court of Appeal, because of these different judgments from different divisions talking about the same issue, having a total different view. Like I explained earlier, how you can look at the exact same picture and see a different thing. He differs from Judge Brooks, gave a direct imprisonment, quite a substantive one, in that Romeo Johnson appeal matter. Your Worship, I want to be upfront that the state is seeking a custodial sentence, and if we can get the maximum sentence of 15 years, counsel correctly said that we do not rely on the Minimum Sentence Act. We do rely on section 121, which refers to the maximum sentence of 15 years. And I'm going to tell the court why we are relying on that particular sentence, or the request to impose at least a 15-year term imprisonment. Your Worship, without being prescriptive, it is correct that the custodial sentence will send out a clear message. Counsel referred earlier about this happen regularly, where people just send fire shots at events, at funerals and so on. I must say, I only saw, not saw, but saw it on television once, is the one that was highlighted by the deputy mayor, I think, of the Nice Now George municipality. The outcry because of that shows that that should not be tolerated in a civilized society, where people's lives are placed in danger for people who are in a celebratory mood, firing shots. And in most cases, these people are unqualified to fire such shots. In this instance, accused did not just fire one shot and left it at that, which we can consider to be an accident. He was malice, to say the least. His actions constituted extreme danger to the 20,000 plus people that were present, not even mentioning the community right around Mdantsane, which we know is one of the biggest locations in South Africa. It's condensed, it's densely populated, and especially on a weekend, it is busy in Mdantsane. It was by the grace of God that nobody got hurt.
I think I repeated that, I said this on the 23rd of January. If there is such a response, I'm not going to ask you to be quiet, I'll order you to leave. There won't be a choice. Understood? Please interpret, Ms. Magwa. You may watch outside if it's going to cause a delay or noise. Ms. Magwa? Advocate Caesar, you may proceed.
Thank you so much, Your Worship. The accused is a political leader. He's got a huge following. Young people emulate this type of behavior. What he doesn't realize is that he already opened a Pandora's box where he creates the impression that this type of conduct is acceptable. What did Pastor Mboro do? He grabbed a firearm, ran to a school, screamed it was a toy firearm. The deputy mayor of the Nice Now George municipality fired shots, screamed it was a toy firearm. That's the precedent that he set. That people think they can get away with doing these type of offenses.